Hello, this is Rocco Beatrice. I'm the Managing Director for State Street Partners. And today I would like to discuss with you the Irrevocable Trust. Well, an irrevocable trust, when implemented correctly, funded correctly, it is the strongest asset protection device in the United States that you can possibly buy outside of going offshore. The prerequisites to having an irrevocable trust is the independence of the trustee. The other is how you fund the trust. How do you move assets from you to the trust without incurring the probability of a fraudulent conveyance or a gift tax? I can't tell you how many times we get calls from individuals who have a trust 4 or 5 pages long, and the discussion centers around the fact that when you transfer the assets to the trust, what did you get back? Did you file a gift tax return? Well, this would be considered a fraudulent conveyance, because you can't simply give away your money, because that money would have been available to a creditor. In order to establish a truly strong irrevocable trust, you must have an independent trustee. You must be able to exchange your asset for another asset so you avoid the fraudulent conveyance. Fraudulent conveyance means that the asset that you transfer was at less than the fair market value. An example would be that, let's say you have a car, a Mercedes-Benz $48,000, and you give it to your brother for $10,000. Well, you just did a fraudulent conveyance. But however, if you sold it to your brother for the exact same amount of money, which was worth $48,000, there's no fraudulent conveyance. Because in your hands, what you have in your hands is $48,000 that would be available to a potential past, present, and future creditor. Another thing that makes our trust, our ultra trust, the irrevocable trust, not only the fact that we have all kinds of provisions as to what the trustee can do and be an independent trustee, we have added the trust protector as the balance between the grantors, the original people that funded the trust, the trustee, and the beneficiaries. The powers of the trust protectors are enumerated in the contract, but 2 basic things. 1, he can fire the trustee. 2, he can veto distributions and require signature on transfers in excessive amounts. The irrevocable trusts, they're not all the same. They're based on who wrote the trust. Now, our particular trusts are between 35 to 45 pages long. We cover all kinds of potential issues, such as if you have minor children, if you are going to be divorcing, if one spouse dies and remarries, can the new spouse become part of the trust? All of those depend on who wrote the trust. 35 to 45 pages long, we cover an awful lot of real life material based on a 35 years experience. Whenever we find that one of our trusts lacks in circumstances, for example, the latest change that we have made is related to the Medicaid spend-down provisions. Medicaid spend-down requires if you have assets, you got to pay the nursing home until you reach $2,000 of your own money. Well, what we have done for that is that we have included paragraphs limiting the fact that if a quasi-governmental agency or the state agency related to collection of Medicaid, in our trust agreements, we have paragraphs to eliminate that possibility by stating that if any attacks by any one of the Medicaid or state enabling acts, we consider the asset protection trust to be written prior to their deceased. We consider the beneficiary to be deceased prior to writing the trust. This is Rocco Beatrice. For more on this subject and other subject matter, please visit ultratrust.com.